And while the lawmakers debate on whether the heartbeat law will actually go forward, there are some questions on if it would violate Georgia's Constitution's right to privacy. 11 Alive's John Sherrick picks up our coverage.
What would happen if someone were to claim that Georgia's pending new heartbeat abortion law violates the state constitution's guaranteed right to privacy?
In Georgia, the battleground is going to shift from the federal courts to the state courts.
Fred Smith, professor with Emory University's School of Law, says it is possible there could be a state court challenge to Georgia's new law, the law that would ban most abortions once a fetal heartbeat is detected, usually at 6 weeks.
The Supreme Court of Georgia has said time and again that our state right to privacy is stronger than the federal right to privacy. And so we'll see exactly what that means with respect to laws like the 6-week law.
Across the country, according to a U.S. News study, 10 states have already decided that their state constitution's rights to privacy specifically guarantee abortion rights.
And it's not unusual for some state Supreme Courts to be well ahead of the Supreme Court on these kinds of issues.
Professor Eric Siegel with Georgia State University's College of Law says if there is a lawsuit in a state court against Georgia's abortion law,
all rise.
The case could end up before the state Supreme Court for a ruling on whether Georgia's law violates the state constitution's right to privacy. And that could be the final decision on Georgia's law.
A Georgia Supreme Court decision based on the Georgia state constitution cannot be reviewed by the United States Supreme Court unless the Georgia state opinion itself violates the Constitution.
In other words, the U.S. Supreme Court would likely have no power to overturn a state Supreme Court ruling on whether Georgia's constitutional right to privacy includes access to abortion. In Atlanta, John Sherrick, 11 Alive News.
And right now, all across Metro Atlanta, there are several district attorneys who say that they will refuse to prosecute cases under the heartbeat law. Gwinnett County is joining Fulton, DeKalb, Henry, and other Democratic-controlled counties pushing back against this bill. Gwinnett County DA Patsy Austin Gaston says that she will not completely rule it out, but says her office is already too busy handling violent and other crimes, and they need to set priorities.
I think that law has a long ways to go before it even becomes one that we will prosecute. You have to look at how a jury would even look at those type cases.
So experts say it's possible a judge could order a prosecutor to try an abortion case, but the state would have little power to compel a prosecutor. For more on our coverage of Supreme Court's decision to overturn Roe v. Wade and what it means for all of us Georgians, just check out this story on 11alive.com.